Welcome back everyone, I'm Alex and I'm excited to share another insightful episode of Money Magnet, where we will be exploring a topic that is essential for any South African, estate planning, and the importance of having a last will and testament, together with my co-host Anna.
Hello everyone, today we would like to shift our focus from our usual course to ensure you're not just financially efficient in your day-to-day life, but also secure in the long run. And to help us navigate this important topic, we have invited a special guest, an expert on estate planning.
Now, before we introduce our guest, let us give you a definition of what estate planning is.
Estate planning is a thoughtful and organized process of deciding what will happen to your possessions and assets after you have passed away. It involves making concise plans like creating a will to ensure that your wishes are followed and your loved ones are taken care of.
It also means taking local laws, taxes, and cultural aspects into consideration to make the process smooth and tailored to your unique situation. The goal is to secure your legacy, prevent potential conflicts, and provide financial stability for your family in the future. It can include details on where your loved ones can find your passwords or instructions on what to do with your body. Additionally, it may outline who receives specific items from your belongings.
Joining us is Kerry, an estate planner and financial advisor at Finlac, with years of experience in estate planning. Welcome, Kerry.
Thank you, Anna and Alex. It's a pleasure to be here and share insights on the vital subject of estate planning.
So tell us, why is it so important to have a will in place and what happens if you have one?
I think it's very important first that estate planning is not just about having a will. It consists of looking at your full financial situation and ensuring that if you die, get a disease, become disabled, etc., that there are sufficient funds and plans in place to ensure that your lifestyle and the lifestyle of your family is not impacted in a devastating way. Having a will is a very important part of the estate planning process, but your financial situation needs to be looked at holistically. With regards to a will, it's your written guide on how you want your assets distributed after you're gone. It allows you to choose specific individuals, called beneficiaries, to inherit your belongings. You can appoint an executor in your will, who is someone responsible for carrying out your wishes. If you have a will in place, your assets are distributed according to your instructions and your loved ones have clarity on your wishes, potentially reducing conflicts. For a will to be valid, it needs to be signed and dated. It also needs to be witnessed by two parties, and very importantly, these parties cannot inherit anything in the will.
And what happens if you do not have a will in place? Lots of people tend to avoid this topic and often think they won't die soon anyway.
If you pass away without a will, which is called intestate, the Intestate Succession Act steps in to determine how your assets will be distributed. After your passing, the court appoints an administrator to manage the distribution of your assets. The Act has a default hierarchy, which may not necessarily align with your preferences. Delays and legal complexities which may arise, causing stress for your loved ones.
Kerry, as we explore the fundamentals of estate planning, could you highlight some specific considerations for our South African listeners? Are there any specific legal or cultural aspects that they should be aware of?
Certainly, Anna. In South Africa, it is important to understand the legal framework and cultural nuances. As mentioned, the Intestate Succession Act may come into play if someone passes away without a will, and this can have specific implications, specifically for blended families.
So what does that mean? Can you tell us a little bit more?
In South Africa, the legal framework for governing the distribution of assets in the absence of a will is defined by the Intestate Succession Act. When an individual passes away without a will, they are considered to have died intestate. In such cases, the Intestate Succession Act outlines a set of rules that determine how the deceased person's estate will be distributed among their heirs. Now, the implications of this are particularly noteworthy for blended families. A blended family typically includes stepchildren, and without a will, the Intestate Succession Act may not adequately address their rights to inheritance. This can lead to potential complications and disputes, as the Act primarily focuses on biological and legally adopted children. It is also important to note that there is no common law marriage in South Africa. This means that if you are not legally married or have a cohabitation agreement in place, you may not be recognized as a spouse and be able to inherit. This means you may be forced out of the home you are living in, not inherit anything, lose income, etc. Therefore, understanding and navigating the legal intricacies become vital in estate planning for blended families and unmarried couples in South Africa. It underscores the importance of having a carefully crafted will, ensuring that the distribution of assets aligns with the individual's specific wishes and family structure. This legal awareness is fundamental to preventing unintended consequences and fostering a fair and harmonious transition of assets in the absence of a will.
How about the role of trusts in estate planning? I know they can be very useful, but might not be familiar to many. Can you shed some light on that, please?
Absolutely. Trusts, although not for everyone, can play an important role in estate planning, serving as powerful tools for the effective management and protection of assets. To shed light on this, it's essential to understand that trust provides a structured legal arrangement where assets are held by one party, being the trustee, for the benefit of others, the beneficiary or beneficiaries. The flexibility of trusts is a key advantage. Unlike a straightforward inheritance through a will, trusts allow for a more nuanced and customized approach. This adaptability is particularly valuable when the needs of beneficiaries vary or when there's a desire to implement specific conditions for asset distribution. Trusts are often tailored to suit the unique circumstances of the individual and their beneficiaries. For example, they could be set up to provide financial support for minor children until they reach a certain age, or to distribute income to beneficiaries at specified intervals. This level of customization ensures that the assets are managed and distributed in alignment with the individual's intentions and the specific requirements of their beneficiaries. Moreover, trusts offer a layer of protection for assets. They can shield assets from certain taxes, creditors, or legal disputes. This aspect becomes especially relevant in estate planning, as it contributes to the preservation and efficient transfer of wealth to the intended recipients. In essence, trusts are versatile instruments in estate planning, offering a strategic and customizable approach to asset management and distribution. They provide a level of control and protection that goes beyond what a simple will can achieve, making them a valuable consideration for those looking to enhance the effectiveness of their estate planning strategy. There are, however, tax implications to having a trust, and quite strict administrative requirements. A possible more admin and cost-friendly option might be drafting a will which includes, at your death, a trust to be created to ensure that minor children are looked after. This is called a testamentary trust. This trust is only activated at death, and you are able to nominate the people that will look after your children in case of no natural guardians, and you can nominate the people that will deal with the financial requirements for your child or children. If you die intestate with minor children, their inheritance gets placed in a guardian's fund. An applicant, being the guardian of the child, can claim maintenance or an allowance from what is now called the Guardian's Fund. The Master of the High Court may pay from interest as well as up to 250,000 Rand a year from the invested capital for maintenance, like school and university fees, clothes, medical fees, boarding and lodging, and any other needs that can be and need to be fully motivated. Just a note on this is 250,000 Rand a year, and for those that have children, know that this may not be sufficient funds to look after your children adequately.
Very cool. So, in essence, going with a will that includes a testamentary trust, if you perhaps have minor children, would be the sensible thing to do.
In the South African context, people often have extended family responsibilities. How can individuals address the needs of a broader family network in their estate plans?
That's a significant consideration, Anna. Communicating openly with family members and including provisions in the will to support dependents and extended family can help avoid potential conflicts and ensure that everyone is accounted for. Estate planning will make the lives of your loved ones considerably easier. Let's be honest here. The last thing we want is having to deal with a difficult estate or complex family situation because there was no plan by our next of kin. Good planning will help the people you love if you pass away.
Very true. And how do you approach the misconception that estate planning is only for the wealthy? Many might believe they don't have enough assets to warrant a comprehensive plan.
It's a very common misconception, Alex. I often emphasize that estate planning is about more than just the value of assets. It's about ensuring a smooth transition and in safeguarding the well-being of loved ones, regardless of financial status.
That makes a lot of sense, Kerry. Considering the diverse cultural landscape in South Africa, how can individuals ensure that their estate plans align with their cultural values and traditions?
Cultural sensitivity is crucial. Understanding and incorporating cultural values into the estate plan, such as customary marriages and specific rituals, can be essential for a plan that truly reflects the individual's wishes. For an example, Muslims need to be buried within a short time frame after they have passed away. But it could boil down to you not wanting to be buried, but rather cremated after your death. The individual wishes will make the lives of the grieving family so much easier. I can promise you that.
And what about digital assets? In an increasingly digital world, how can individuals ensure that digital assets are managed appropriately in their absence?
Good question, Alex. It's vital to include digital assets in the estate planning, providing clear instructions on how to access and manage these assets. Everything from social media accounts, passwords, cryptocurrency, etc.
Really good point. Could you give us an example of how to deal with that?
Including digital assets in an estate plan has become increasingly important in our digital age. Digital assets encompass a wide range of online accounts and files, including social media accounts, email accounts, digital photo libraries, and even cryptocurrencies. For instance, many social media platforms, including Facebook, offer options for users to plan for the management of their accounts after they pass away. Facebook provides a feature called Legacy Contact, where users can designate someone to manage their account or memorialize it. This allows the chosen contact to make specific decisions about the account, such as writing a pinned post, responding to new friend requests, and updating the profile picture. In terms of email accounts, individuals may want to create a document listing all their online accounts, usernames, and passwords. This document should be stored securely and shared with a designated executor or trustee outlined in the estate plan. It's crucial to keep this information up to date, and individuals may also specify in their will how they want their email accounts to be managed or closed. For cryptocurrency, which is a form of digital or virtual currency, including clear instructions in the estate plan is vital. This can involve providing details on how to access the digital wallet and specifying how it should be distributed among beneficiaries. In essence, dealing with digital assets involves a proactive approach. It's about creating a comprehensive inventory of these assets, understanding the platform-specific options available for legacy planning, and ensuring that this information is accessible to the appointed individuals in the event of one's passing. By addressing digital assets in the estate plan, individuals can avoid complications and ensure that their online presence and financial assets are managed according to their wishes. As an example, I have a shared Google Drive folder with my family. This includes a digital copy of my will and policy schedule. It also has copies of my ID, etc. This updates automatically when anything changes. And at my death, this will make accessing my personal information much easier.
Kerry, for our listeners who may just be starting out on their estate planning journey, what initial steps do you recommend? And are there any specific resources or professionals they should seek out?
Starting with a comprehensive inventory of assets is a good first step. Then consulting with a qualified professional, such as a fee-only financial advisor or attorney experienced in estate planning, can help individuals navigate the complexities and ensure their plan is robust. It is also very important to look at your beneficiary nominations on any policy and employee benefits you may have. It is also important to note that beneficiary nominations on any retirement funds are merely wishes, and the trustees of that retirement fund ultimately have the final say as to who they deem the dependents to be. On that note, the Master's Office is currently taking approximately 2 years to settle estates. This means that any funds that your family may need to continue living may be tied up for that length of time. So beneficiary nominations on policies are incredibly important, that money can go directly to the people that need it the most. It is also important to note that overseas assets also need to be included in your will, or you need to have 2 separate wills. But whoever is drafting your will needs to be aware of these assets, as it could have major repercussions if drafted incorrectly.
And how can individuals ensure that their estate plan remains up to date, especially with life's inevitable changes?
Regular reviews are key. Life events such as marriage, the birth of children, or changes in financial circumstances could prompt a revisit to the estate plan to ensure it reflects the individual's current wishes. This can be something as simple as buying a house.
What are the costs involved in estate planning? I think many people might be intimidated by the thought of that.
It's a valid concern. The costs associated with estate planning vary based on several factors, including the complexity of your financial situation, the types of assets you hold, and the specific legal and financial services you require. One of the primary costs is the professional fees for engaging experts such as financial advisors, attorneys, or estate planners. These professionals play a crucial role in ensuring that your estate plan is legally sound, tailored to your needs, and compliant with relevant regulations. Their fees can vary based on their experience, expertise, and the scope of services provided. Additionally, there might be expenses relating to drafting legal documents, such as wills, trusts, and powers of attorney. These documents require precision and legal knowledge, contributing to the overall cost of the estate planning process. In some cases, there could be fees associated with updating or amending your estate plan, especially if there are changes in your life circumstances, such as marriage, the birth of children, or changes in financial status. While these costs may seem daunting, it's essential to view estate planning as a long-term investment in securing your financial legacy and providing for your loved ones. Engaging in comprehensive estate planning can potentially save money in the long run by avoiding legal disputes, minimizing tax implications, and ensuring a smoother distribution of assets. Moreover, many professionals offer initial consultations. This is where you can discuss your situation and get an estimate of the potential costs involved. This can provide clarity and help individuals make informed decisions about their estate planning journey. Remember, the peace of mind and protection offered by a well-crafted estate plan can often outweigh the initial financial investment. Also, there is National Wills Week once a year, where one can get a free will drafted by an attorney.
Now let's share a bit about our own experience with estate planning. Alex, you and I had a shared experience as a friend of ours passed away in a motorcycle accident and he had not left a will for his partner. Do you want to tell us a little bit about that?
Well, that was quite an eye-opening experience. I was asked to assist with translating as his family didn't speak English very well. So I accompanied them to all sorts of appointments. As such, I was present when everything was discussed, and it turned out they didn't even have the password to his laptop. They didn't know if they were aware of all his assets and so on. In addition to dealing with the emotional pain of having a loved one ripped out of your life unexpectedly, they had to deal with a lot of unnecessary admin and stress to get hold of all that information. After that, I contacted a lawyer to draft my last will and living will. I was in my early 30s at the time and certainly did not expect to die anytime soon, but then again, who does? I have no family in South Africa and wanted to make sure that my then partner had power of attorney in case something happens to me and can make decisions on my behalf. I had seen the mess that was left behind without a will and wanted to avoid that at all cost. I asked my now ex-partner to do the same, as his family lived all over the country but no one in Cape Town. And he had a living will drafted, giving me power of attorney over his accounts, for example, in case he becomes hospitalized or otherwise incapacitated. But funnily enough, he refused to get a last will. To him, dealing with that meant facing his own mortality, and the thought of death scared him. Since I knew that his family would need his money more than I would have, I was perfectly fine with it. But I always thought it was a strange reason. I know that a lot of people fear death, and dealing with your estate planning might trigger your fears. But I have seen firsthand the mess that is most likely left behind if you do not take measures to ensure people know where to find all relevant information and know what you want. Facing your fear of death is much better than leaving your loved ones in such a mess afterwards.
Absolutely. Next to this experience, a friend of mine had an ugly legal battle with her former in-laws, all because there was no estate planning done. In fact, my friend was even deceived that a will had been given to the bank, only to realize that nothing was in place as a spouse passed. What a terrible realization to have when all you want is to grieve because you lost your significant other. So I cannot stress enough how important it is to provide clarity and security for your family. This is also why our will, I have one with my husband, is with our financial advisor. I also made sure that the people who are to inherit anything will be informed or already have our will. Furthermore, we've also taken steps to communicate our wishes clearly and have engaged in open conversations about our financial plans, ensuring everyone is on the same page. I do not have a trust, and I also still want to create a file with all my passwords to which at least my husband has access in case I'm no longer able to communicate or pass away unexpectedly.
Thank you, Kerry, for sharing your expertise on estate planning tailored specifically to the South African context. We hope these insights helped our listeners in securing their financial legacies.
Thank you. Estate planning can be perceived as a daunting task, but the benefits of a few hours of planning now far outweighs the issues that may arise later, so it's best to start as soon as possible. And start by having a simple will drafted and seek professional advice.
Remember that estate planning is a difficult but really important part of your financial journey, and if you have not done so already, we would like to ask you at least to start thinking about the topic.
Exactly. We would like to encourage you to write down if you would like to be an organ donor or not. What should happen when you are not able to make medical decisions due to illness or an accident, basically a living will, and what should happen to your belongings. Maybe you do not want your family to receive anything. Maybe you want it all to go to your favorite charity, or just want your family not to fight over what is left. So please start the process, because none of us is guaranteed a tomorrow.
And on that bombshell, we would like to say until next time, stay informed and continue to be a money magnet!